right, Jacob Mann, 25M5681. Now, Mr. Mann, I want to clarify here something. I've got a public defender over here, and Mr. Piaggi, who's not present in the courtroom, had told me that you wish to represent yourself today. I want to hear it from you.
Yes, ma'am. I'm aware of the, I believe it's the Arguello advisement and all that. And yeah, I definitely feel more comfortable having my right to be heard reserved rather than let somebody speak for me on this matter.
Okay, well, I want to make sure that you understand you're wearing stripes, so you are entitled to have that public defender.
Yeah, no, I think I'd rather pass. No disrespect or nothing. I just feel like from our talk that like she's not really aware of like the whole statutes and things like that involved in what I'd like to say or represent.
Well, I tell you what, she's in my courtroom every single day.
I'm not saying, like I said, no disrespect.
No, I know. I just,
you know what I mean? When it comes down to some things like that, I just freshly researched and what she was saying just ain't matching up. You know what? I'll take the chance.
Okay, well, that's your right. Now, Mr. Mann, have you talked with Mr. Duncan? Because if you're going to represent yourself, Mr. Duncan is the prosecutor, and depending on the circumstances, might want to convey with you some type of an offer in the case.
I would love to speak with him if he's willing.
Mr. Duncan?
A couple of issues, Judge. First of all, the people aren't very compliant today to extend an offer, but we're obviously working on that. The second thing is that Mr. Mann on 2 felony matters, in one of them he has advisory counsel appointed, and in another one he has ADC appointed, and I'm not sure of the scope of that representation. So I'm just a little reluctant to potentially tread on his rights by, if anything comes up with those cases. So.
That's a maze to navigate, isn't it? So, Mr. Mann, let's pick apart what Mr. Duncan just said.
All right.
First of all, okay, I'm gonna go ahead and just advise you here. Did you receive a form? I want to make sure you, if you're representing yourself, that you have a form. Could Ms. Vigil, could we get a form for Mr. Mann?
So
this is your advisement of rights.
Okay.
And I want to make sure that you have one available.
Yeah, we can do that.
And that you have a chance to review that.
Did you want me to actually like fill this out and sign it and all that?
It's nothing that needs to be filled out and
Okay.
signed. I just want to give you a chance to review it, okay?
Yeah. Yeah, I'm aware of all these actually.
Well, take your time. I'm not rushing you.
Right. Basically today, you know, I understand that the state's not ready. They have had no contact with their main witness. They really probably don't even honestly need to.
Okay, well,
with
hold
the
on.
evidence that they have.
Make
However,
sure that you've read your form. That's the
yeah,
first.
no, I understand all my rights when it comes to like, yeah, I'm aware of these. I mean, as you guys see, I've had a little bit, not
Okay,
proud, lengthy history.
Is my
I'm
job,
aware.
hold on, Mr. Mann, my job today
Okay,
is pretty basic.
all right.
And one of those things is to make sure you understand those rights.
All right, we'll take
So-
it slow. Sorry.
So my first question is going to be, did you review your rights? And I want you to be able to answer yes, so that my second question is meaningful, and that is, did you understand your rights? So just give it a second.
Yeah, if you want me just to read these real quick and.
Yes,
Yeah,
please.
okay, I got you. So this is the arraignment? Is that where we're at on this? This is today?
That's
Arraignment?
exactly right.
Right?
Mhm.
Yeah, so this is the day speedy trial starts?
No,
Target set?
no, speedy trial starts when a plea is taken.
So after,
So
Yeah, okay,
when you
that's what I
go
thought.
before the court, speedy trial begins to run when the plea is taken.
yeah, I wish to reserve all rights and continue pro se, if we can go ahead and run that.
Okay, so my first question is, did you review all your rights on the
Yeah,
form?
yeah, I'm very well, yeah, I know these rights.
Any
I've seen them many
questions?
times.
Any questions regarding your rights?
Not at this moment.
Okay. So here you are facing several charges. The most serious charge is a Class 1 misdemeanor. The maximum penalties on a Class 1 misdemeanor are up to 1 year in jail, a fine of $1,000, or both, or a lesser combination. You are not facing any mandatory sentences, however. Okay?
Yep.
You understand your rights, or
Absolutely.
understand the penalties that you're facing?
I understand the penalties, ma'am.
Okay.
I mean, Your Honor, sorry.
Anything you say is fine.
All right.
Okay. So in hearing Mr. Duncan today, the people have not yet gotten a hold of the victim, and that must happen first. So until they have talked with the victim about a plea, potential plea offer, they can't make a plea offer to you. So
Right.
Ms. Benninghoven will hear of any information before you do, and then the people will be ready to go. So
So,
for today's purposes, I'm going to send you to a trial division. Okay? This is the arraignment division. I'm going to send you to county court where you can get your case set for trial.
yeah, that's cool.
Okay?
Um,
Do you have, Mr. Duncan, are both these cases in district court, or is there a county court matter?
There's a 22 CR, which is up in Division E, and a 25 CR also up in Division E. So I think this can just go to Division 5, I think is the week.
I'm not
Oh.
trying to have all my cases in the same courtroom now, you know what I'm saying?
Right, except this is a misdemeanor and your
Yeah,
other two
no, I
are
understand,
felonies. So
the jurisdiction type issue. So,
I'm going to go ahead and send you into the county court.
okay,
We
something
were-
I'd really like to address today if I
Okay,
can,
hold
whenever
on, I
you
need
got
to
a
give you a
second.
date,
Yeah.
one thing at a time. Let's give you a date first.
November 5th at 8:45 in Division 5.
Thank you.
Okay, so November 5 at 8:45 in Division 5. Your judge will be Judge Nowak,
Which court
N-O-W.
number is that?
That's courtroom 303.
303, all right, cool. Thank you, Your Honor.
Okay?
Yeah.
So we've gotten you your county court judge.
So this is basically just being set over, this hearing?
This is being, that's exactly right. This
Alright,
is what
so-
we call our first appearance center, and then cases are routed from here. Now, you said you had a question. I'm
Well, you
not
know,
sure that I can,
I think it's kind of good that he hasn't spoke to the victim yet because, you know, I'm asking for basically a modification or a dismissal of the order, basically, and I have it all in writing here. I'm gonna have to need to amend it, but I know that there's like a 10-day deal on basically this request or application rather to the court. So I was wondering if basically I might be able to just get a copy of this and give you guys a copy and let me have a copy and we can kind of go from there.
yeah, I don't know of any time limitation on, I guess
Yeah,
I
no,
don't
I was
know
just looking at the
specifically
statutes
what
this
you.
morning.
what
Said
you
10
might-
days within the, basically the receipt of the mandatory protection order. And basically under the mandatory protection order, there's a clause that says, you know, to the defendant, I can apply to have it modified at any time. And I guess no better time than now since he hasn't spoke to the victim yet. So,
Yeah, well, until the victim has been notified of a request such as that, I can't touch it. So.
well, actually you
that-
can because it's actually part of my rights as the defendant in the case and that's on the protection order you guys gave me. So if I have the paper here, hold on one second. It appears that I lost one somewhere. Hold on. It's actually, I mean, you guys got it on file on the record. I mean, you really don't need me to give you a copy of it twice, I don't think. So it's right here on the protection order you guys gave me, page 3 of 3 on JDF 440. If you look at the first part, it says you may apply at any time for the modification or dismissal of this order. So then here's you go. If you want to take that, please.
Mr. Duncan, if you could gather whatever the defendant is
I mean, I don't know. It
having.
says it right here in the order that you guys gave me, so I just,
All right,
I'm not
Mr.
trying to be
McKee,
rude.
I've heard you, Mr. Mann. Let's go ahead and let Mr. Duncan take a look, and then I'll take a look, okay?
I mean, if you guys want to copy the order, I can give you it too. No, you don't need that? Okay. Sorry. If I could just have a copy, y'all can take that with you. Just call this one done. Go ahead and take this. Thank you for the rights. I will probably make an amendment to that at some point due to the basically lack of law library.
It looks like, first of all, we're not very ready to address the protection order, so Mr. Mann can obviously make his motion and then the court can hold it maybe in abeyance while we get into VRA compliance for the modification of the protection order. He's referencing 13, 14, 108, which is a modification of a civil protection order. So I think any law that he's referring to is not relevant to the modification of a criminal protection order. So the law he's relying on is the wrong law. He's referring to 13-14-108. And even if he does have that right to apply to be modified, my position would be that the court would need to maintain the VRA right of the victim to
All right.
be consulted on that.
Mr. Duncan, if you could actually hand that up to me, I'm going to have my clerk make copies.
Thank you very much. Because that's actually,
Ooh, this is really faint.
yeah, I know it is. That's just what they gave me to use at the jail, you know, resources are very limited there. The law library is from 2010. It's not really updated. However, within that section that he mentioned, they actually reference 18-1-1001, which is the criminal protection order. So you might want to brush up on your laws there, Mr.
Well,
Duncan.
that's not nice, Mr. Mann. At this
Well, I know,
point,
he's just trying to reject it because he doesn't want to address it, and that's.
Mr. Mann, we don't talk like that in the
I
courtroom.
apologize, you're right, that was very unprofessional of me, it won't
it
happen
is.
again. I'm sorry,
So
I apologize to
Here are
everybody.
victim rights amendment. It's
Sorry, I don't want that.
both a constitutional right and it's codified in our statute.
I'm
And
basically just
specifically,
requesting-
please,
Sorry,
I
I'm
need
sorry.
you to
I'm
be
sorry.
quiet now. It's
Yeah,
my
I will,
turn.
I'm sorry, I'm done.
Under 24, 4.1, 302.5. This is a victim rights case, and the victim has the right to be notified before any modification of a protection order takes effect. So I will go ahead and take your motion today, but I'm
Thank you.
not going to address it today.
No, I wasn't asking for that. I just wanted to be, because, you know, I didn't think the victim would be notified by this point, and I was hoping that maybe basically all I'm asking for is the same protection with my name for her to like contact me, because she's been making attempts at the jail to like on the home wave thing, the community, you know, the telephone system there. She popped up on there. I deleted her. She came back. And like, there's been issues where like, you know, I've been also assaulted by her, and like, obviously I haven't turned in no evidence of that yet, but like, except for like my testimony within this motion saying, hey, like, I'm asking for the same protection that she's given. Because it can't be a one-way street because of the fact that like, this incident that's in question that is going to be litigated wasn't just a one-way matter. There was things back and forth done. I just told the police, look, I don't want her to go to jail because like, I don't feel like that, number one, she's not equipped to handle that. And obviously like, I don't
All right,
want to
well-
bring damage on her. And number two, I wasn't at a point to where like, I'm able to furnish any evidence against her because of like the situation. I just wanted to make the court aware that like, look, all I'm asking for is a modification to include me with the same protections that you guys are giving her, because there's been assaults both ways and damage of like, you know, various forms. That's all I'm asking. So I know we
Right,
can't
and Mr.
address
Chair,
that.
that will be addressed at a future time.
Absolutely. That's all I'm asking.
We've got your motion on file. We're
Thank
done
you.
today.
Thank you.
Thank
Sorry.
you.
Sorry. And hey, I really didn't mean any disrespect to you, Mr. Duncan, or the court. I apologize. It won't happen
Well,
again.
but yeah, just be careful, Mr. Mann, because when you represent yourself, I do expect you to act like an attorney and be professional.
All right, now we're ready.
Thank you, Your Honor. Can I please call, and this is kind of a strange situation, Mr. Jacob Mann. I only represent him on one case. That's 25 CR 2733.
Okay.
So advisory council is present. This is going to be an FTA, so I think the court maybe will want to call the other case at the same time. Mr. Mann. Okay.
Do you want to pass it then and talk to him before we call it?
No, Your Honor, I still need to go to Denver, so I'm gonna ask for the court to set a new court date for Mr. Mann, and we'll still call it.
All right, so 22 CR 2848 and 25 CR 2733, Jacob Mann, entries of appearance. Well, just to be clear, Mr. Mann is here pro se, representing himself on 22 CR 2848. And then entries of appearance on the other cases. And I'm sorry, Mr. Duncan's here on that case also for the people.
And Nikki Nelson appearing as friend of the court on 25 CR 2733. Mr. Mann did bond out on that case early in October, was informed he needed to apply for the public defender's office, has not done so yet. So I'm going to ask for another court date for him. But if that application isn't turned in, I won't be appearing at it. So I just want that. He was advised by the court previously on 1028.
Mr. Mann, are you intending on applying for?
Well, Your Honor, I mean, I don't really know what's going on here because they merged both these cases together on the same day.
But they're not merged together. Let me
They're not?
explain to you what's going on. And
Yeah.
it seems like you keep on having difficulties understanding some pretty clear
It's not that.
direction of the court. Hang on.
Sorry.
The cases, there's two cases now pending against you. One is set for trial. You have filed multiple motions on those matters. To be perfectly honest with you, there's zero record before the court in either one of the two cases that you're indigent. So I've already ruled on two of your motions, one of which was filed while you were in custody before you bonded out. That's in case number 22 CR 2848. That was where you were requesting an investigator. I've denied that motion because I have nothing before me that indicates, and I'm sorry, Ms. Jones, my apologies. Ms. Jones is here as advisory counsel on case number 22 CR 2848.
Thank you, Judge.
Thank you. And I apologize for that, ma'am. I forgot there's got to get the advisory counsel in here too. So, sir, Ms. Jones doesn't represent you on that case, but she is advisory counsel. The reason I entered the orders is I have nothing before me indicating that you're indigent. At this point, you have not applied for the public defender in case number 25 CR 2733, and the public defender's office was representing you in that case while you were in custody. They're two separate cases. They just happen to be set on the same date, so we can address the matters on the same date, but we're addressing everything separately. The other issue the other motion that you filed that I didn't really deny, it's really there's just no action that was required, is that you file a motion to extend the motion filing deadline for 2 weeks. But you filed that when the motion filing deadline was well beyond 2 weeks, and you actually filed that while you were in custody, and you've been out of custody for more than 2 weeks. And frankly, the motion filing deadline was yesterday, and I made that very clear. So, we did set this matter at one point on 11/4, but we didn't address anything because you had not received proper notice of that. So nothing was addressed at all in that case. But on 9/23/25, when you were in court, the court made it clear that the motion filing deadline was the 24th, which was the day before today, because today we were going to address kind of what was going on with motions at that point. I've not seen any, you have certainly filed some motions since that on case number 22 CR 2848. I've not addressed those motions at this point. The prosecution did file a response to your show cause motion, but nothing else has been addressed. I did rule on 2 of the motions because I felt like I had sufficient information to rule on those. And again, in one of them, really it was just you didn't need an extension. But having said that, no new motions have been filed. Last motions that were filed were on 10/20/2025. We're currently set for trial on case number 22 CR 2848. And I guess I am prepared to address at least the motion to show cause here today. And so that's the background. Now, the question is on 25 CR 2733, on that case, are you planning on applying to a public defender in that case?
And Your Honor, I think maybe I just want to clear some things up for Mr. Mann and make sure that the record is clear. Ms. Jones said I might have misspoken and murkied the waters here.
I don't think you have. I'm just trying to find out whether he's been very clear he did not want public defender
Correct.
appointed in one case. So I'm just trying to find out what he's doing on the other.
I just want to make sure that he understands it wouldn't be for the public defender. You just have to qualify for their office and then you would have ADC. So I just want to make sure that
that's not actually accurate.
There's a conflict on my case.
Oh, on your case.
Yes.
I'm sorry. Okay.
Yes.
I'm sorry. I apologize. Now I'm murking up the waters here.
Yes. So on my case, there's a conflict with the PD's office.
Okay.
So they would not represent you. I would still represent you, but then you need to qualify through that application. So that's all. I just wanted to make sure that was clear, and Your Honor can proceed with your question. I apologize.
Yeah. So and I'm sorry. So Mr. Mann, I've kind of made that confusing. So let me just clear it up. So just procedurally, this is just a procedure that has to be followed in every case if a defendant is indigent and is seeking counsel. If you want to be represented in case number 25 CR 2733 and not proceed pro se or by yourself, meaning representing yourself. In that case, you got to apply to the public defender. Sounds like they have a conflict. If you qualify, if you're indigent and you qualify, then the Office of Alternate Defense Counsel gets appointed, which are attorneys who don't work for the public defender, but they are on a list to be appointed to represent indigent defendants when there's a conflict. That's a procedure you can follow. So is it your intent to seek to do that, follow that process? Do you want representation of counsel in 25 CR 2733?
All right, thanks for the clarification, sir. I appreciate it. You know, there's really not confusion on part of like really the basic issues, like you said, on what's going on here. It's the fact that there's so many procedural defects, lack of notices, constant throughout the history of this first case and this second case, 2733, that I've been trying to address since pretty much since the beginning, ab initio or whatever you want to say. And, you know, I've had a hard time being able to basically communicate with the courts. You know, I've had some technical difficulties. My computer crashed. I've been trying to find the backup of these files on the drive, and I'm struggling. I ain't gonna lie. But, you know, I got in it, and I'm hoping that basically I asked for the extension because, you know, I got out and like I had an issue with where I used to live.
Right now, I'm just trying, and I don't mean to cut you off.
I'm
I'm
trying to
not.
explain myself.
That's the show cause order on 22 CR 2848.
So,
I'll allow you to do that. Right now, I'm just trying to find out whether you want an attorney or not.
Basically, here's the deal. Like, I haven't even got proper notice of the charges. I've not got one piece of paperwork in the case whatsoever, which is basically violation of due process. I don't even know what the charges are or nothing. I've never been served a summons and complaint. I've never been served an information, nothing like that. It's a major constitutional violation. Number two, basically, on the show of cause order, I mean, I'm not sure where we stand on that, but I believe that
Sir,
I basically have a
I'm
right-
only addressing 25 CR 2733.
Yeah,
On that case, you appeared in custody
So
with the
I need
public
some
defender,
evidence
and you were
before I
served
decide.
with let me speak.
Well, I'm sorry. I was
On you keep on making statements about things that are procedurally in defect. I have a minute order from 9/30/2025, wherein case number 25 CR 2733. You appeared in custody with the public defender representing you, Ms. Rosen representing you. You were served with a complaint and advised, and you waived. The public defender was appointed to represent you while you were in custody. And then on 10/28, you appeared via WebEx. ADC Ms. Nelson was representing you in that proceeding. And so this is a pattern that the court has already identified in case number 22 CR 2848 that you keep on saying, and I gave you an advisement under Arguello, talked to you about the fact that representing yourself is risky, talked about the fact that you have to be held to the same standards that attorneys are held to if you're going to represent yourself.
Okay.
Talked about the fact that that it is risky to represent yourself. There's a whole reason why that advisement went through. I've given you multiple opportunities to comply with court orders. I think I've been very clear. The only notice that I will acknowledge that you didn't receive and you were not penalized for was the last court date, because you were in custody and we said it while you were in custody, or at least I thought you were in custody at that time. I think you bonded the next day or the day before. But anyway, we said it to try to bring you in here to address some matters. Because you weren't brought in, I acknowledge you did not have notice of that. There's no penalty, prejudice, or anything that has happened. We just continued to today because you had notice of today. You're here today. And I think the court has been very clear on case number 22 CR 2848 and certainly under 25 CR 2733, nothing that you have indicated here today about not being properly served or receiving notice or being advised is reflected in the record. I'm just trying to figure out at this point whether you want to apply for and I'm going to use the term public defender, but it's ultimately ADC counsel to represent you for Ms. Nelson. If you qualify, because when you're on bond, you don't have a right to an attorney unless you can prove indigency. Yeah, we always have a right to an attorney, to be clear, but you don't have a right to appointed counsel. And if you're willing, if you want to apply, I will give you the opportunity on that case to apply. And then we can turn to 22 CR 2848 to address how we're going to proceed in that case that is already set for trial, and address the show cause motion that is pending on that case. So on 25 CR 2733. Just a question, yes or no? Are you going to apply to a public defender, meaning to ADC counsel or not?
I mean, I'd like to see the complaint first. I mean, I don't even know the evidence they have against me this far. I mean, I don't.
All right, here's what we're gonna do on 25 CR 2733. I'm gonna continue for him to apply to the public defender's office. Again, the record I have is you have been served with a criminal complaint. I'll give you a copy. We'll
Yeah,
print
no,
out a
that's
copy
it.
right now and give it to you.
Thank you.
But you've already been advised on that.
I've been advised, but I never got the paper.
We can get a new court date for arraignment on 25 CR 2733. I am ordering you, making it very clear, you need to apply to the public defender today. Again, it's an application to the public defender to see if you qualify for appointment. If you don't apply today, I'm going to assume that on the next date, you went on Arguello advisement on that case to proceed pro se.
Okay.
All right.
Am I allowed to go get discovery then or not?
Sir, right now you're not represented. So
All right,
yes,
that's
you
all
can
I
talk to
wanted to
Mr.
clarify,
Duncan
that's it.
and you can get discovery and you can proceed as without counsel. You don't have an attorney right now. So yes, you
Okay.
can.
Because, yeah. Thank you
All
very
right,
much for that.
for the record, you're being handed again, apparently, a copy
No.
of the information and complaint in this case. And
The
that's
first
case number 25 CR 2733. Again, the order on that case is go apply to the public defender so that they can determine whether you're indigent. If you are and they have a conflict, they will file something with the court and then an alternate defense attorney will be appointed. Again, that's only if you qualify. If you don't qualify, we'll address counsel issues on the next date. If you don't apply, I am going under the assumption that you want to proceed pro se, and I'm ordering you to do that today. All right, Ms. Nelson, we are,
Can
I think, done on
can I
20.
address something with this complaint?
Sir, you can file something with the court.
Well, I mean,
Or,
under rules 4 and 5 of criminal procedure, it's got to state some kind of,
sir, you've been advised, again, you've already gone through an advisal.
If you're not going to let me talk, all right, I'll be done. Sorry.
If we could just get a date and I'll pre-clear it, hoping that that application gets turned in today and I can
Okay.
stay on.
All right. 4 to 6 weeks on that case.
Can we do January 12th, 8:30?
I'm in Boulder that morning. I'm available the 13th if the court has that.
You do the 13th. She's got
Do you want to write it down?
Well, I have a rabbit.
What's that?
I was just gonna say if you want to write that court date down, but you have,
When was that?
it's January 12th
Oh, okay.
at 8:30, or January 13th, I apologize.
Which one?
January 13th.
I think I might have another court date that day, actually. That might be conflicting.
What case?
I'm not sure.
You only have your Adams cases?
No. But I mean, you're not even my attorney. I don't want to discuss anything with you at this point. I don't know you.
And I hear Mr. Mann saying that date does not work for him.
All right, we'll get another one.
I'm also here the 14th.
Can we do the 14th?
I can accept that, thank you.
Does that work for you, Mr. Duncan? Is that one of your days?
I've got a jury trial starting on the 14th, but if we're going to call it before then, that's totally fine, Judge.
Is it in this courtroom?
It is.
Okay. Then you and I will have the same conflict. All right. So the January 14th, then 2020, this is for specifically for case number 25 CR 2733. The arraignment is continued until, I'm sorry, that was the 14th, right? January 14th
14th.
at 8:30.
Is there any way we could schedule for at least like 9 or something?
No, sir, I have a trial, so we
I
have,
apologize
and
for
I
my
was
mistake.
actually going to say you'd need to be here on time on that date. because
I've
I
been
have-
trying, I'm sorry. It's just, everything's working against me right now, just like right here.
And I think they're still gonna address the other case.
Okay,
All right. All right. So arraignment on that case then again is, and again, sir, on that case, 25 CR 2733, make sure today, after we're done with the other case, you go apply to the public defender. That way a determination can be made as to whether you qualify for whether it's the public defender or ADC counsel, or the alternate defense counsel. All right. All right, then turning then to 22 CR 2733. I did want to address I did want to address the motion to show cause that was filed on 10/9/2025. Again, there have been deadlines in this case have been set multiple occasions. There have been some motions filed by the defendant. There were some motions filed on 10/13/2025. And then some additional motions filed on 10/17/2025 that the court has not ruled on yet, but I wanted to address the motion to show cause. I have read the response filed by the prosecution, and obviously I've read the motion to show cause that was filed by Mr. Mann. To be perfectly honest with you, I don't need to hear argument from either side, but I'm gonna, I guess, I'll give you the opportunity. Mr. Mann, I've read your motion. I see what you've indicated in the motion. Is there anything in addition you want to address?
Just for the show of cause,
Yeah,
you mean? I mean,
as to why you should accept your motions as being filed late is what.
well, I mean, I have a right to present a complete defense. I mean, if you don't accept my motions, it's pretty much like I don't even have an opportunity to defend myself.
Mr. Duncan, is there anything else you need to say in your case?
No, Judge, I'll just rest on what I filed.
Okay. All right. I have considered, I've considered the response. Here's kind of where we're at. Under Rule 41, under Morgan versus People, that's 166 Colorado 451, a 1968 opinion, and under People versus Tyler 874 P. 2nd 1037, a Colorado 1994 opinion. Motions to suppress. I mean, there's at least indication that motions to suppress, even though courts set deadlines, can be filed up to 5 days prior to the trial date. And so even though I frankly share in the frustration that Mr. Duncan, I think, professionally and artfully reflected in his response that Mr. Mann has not met, frankly, and again, I think the orders have been pretty clear, has not met deadlines that have been set by the court. And frankly, that the court, because attorneys have to comply with rules of professional conduct, the court may have a little bit more wiggle room in enforcing if he was a licensed attorney. The court is going to allow the motions to proceed forward. We're not going to address the motions today because we're only set for a status today, but I'm going to set this for an actual motions hearing date prior to the trial date. And that's when we're going to address the motions. This is probably at least the second, if not the third, and it may even be a fourth opportunity, Mr. Mann, that I'm giving you to file motions. You've already filed some motions. You filed a motion for bill of particulars. You've got on multiple occasions, you have actually raised discovery abuse motions. You've filed a motion to dismiss an affidavit, and you got a motion to suppress item C's in unlawful arrests. So you have filed some motions in this case. I'm going to set one final deadline. I'm not granting any extensions for this. I want to make sure the prosecution has an opportunity to prepare for any motions hearings. And so I'm going to set one final deadline because you asked for 2 weeks the last time, and I'm frankly even extending because you had a motions deadline yesterday. I'm only going to give you 2 weeks from today. Or I'll give you I'll tell you what, I'm going to give you until December 12th. So December 12th is when your final motions can be filed. Any motions that you want to address, and we're going to set a motions hearing date today for January, so that, and it'll be early January because the pretrial conference date on this case is this February 10th. So again, your motions filing deadline, to be clear, and I want this in the minute order. Your motions filing deadline, and that's true for the people also. Any notices under 404B, any foreseeable motions in limine, that applies to both of you. That is going to be the 12th of this